One of the things that the Fugitive Slave Law of 1850 did, in addition to making it incumbent upon any American, black or white, to render assistance to those who were trying to recapture fugitives. But one of the things it did was to give fugitives practically no right of self-defense. They had no right to jury trial. They had no right to be taken to court. They had no right to speak on their own behalf. And you know what this does? It means that it makes it relatively easy for a free black person to be kidnapped into slavery. Solomon Northrop had never been a slave. He was a musician working in New York State. He was approached by a couple white musicians who said, "Come with us. We're going to go to New York. We're going to put together a band. We're going to make some money." And he did. And they went to Albany, New York, and into New York City, and they formed a band, and they did quite well. And then they said, "Well, come to us to Washington. We're going to go to Washington, take our band to Washington, and make more money." He said, "Fine." And he went to Washington. And when he got to Washington, he found, because don't forget that Washington is now slave-holding territory, he found that he could easily be and was kidnapped into slavery. He served 12 years in slavery before he could get his freedom. It was not unusual for a free black person to be kidnapped into slavery. And in the mid-1850s, in the city of Boston, a couple black guys were brought before court for carrying guns illegally on the Boston Common. And they explained that the reason they were carrying guns is because they were going to protect themselves against kidnappers. There were lots and lots of examples of slave catchers who came into northern cities, into Philadelphia, into New York, into Boston. Of course, going to Boston was a blasphemy. I mean, Boston was one of the strongest bastions of anti-slavery in the country. But even in Boston, there were slaveholders who came in and recovered fugitives and kidnapped free black people. So that the Fugitive Slave Law sanctioned this. One wonders when we hear those people argue that the Civil War was about states' rights. One wonders at the logic of that. Because, one, the Fugitive Slave Law was a federal law that overrode the state laws, the personal liberties laws that existed in Philadelphia, New York, and Massachusetts, and a variety of places. So that this federal law overriding state law was heartily supported by those people who would later support secession, who would later argue that the South needed to have some way of protecting itself against intrusive federal law. So that when we think about the importance of states' rights, we need to ask the question, if you are a believer in states' rights, how could you possibly support the Fugitive Slave Law? Yet Alexander Stephens, who was the vice president of the Confederacy, argues in the 1850s that it looks as though the federal government is not going to enforce the Fugitive Slave Law, and therefore we may have no recourse but to secede from the Union. It's hardly a states' rights position he is taking here. And so I've always been suspicious of the states' rights argument. It seems to me what the argument ought to say is we are in favor of the states' rights which protect our institution of slavery. When the states' rights don't protect our institution of slavery, then we're in favor of federal rights or federal law.